would have expected that when it comes to labor law work, which is what the labor court cases are about, you would be quicker to hand down judgments because you are very familiar with that field. We have heard from what you have said that when it comes to High Court and Magistrates Court, since about 1996, you have not appeared in court as a lawyer because you decided to do CCM Industrial Court and CCMA work and preside and be a commissioner. So in terms of non-labor, that's where one could have expected that maybe you would have reserved judgments, but you didn't have reserved judgments there and had a long list of reserved judgments in the labor court. It gives the impression, maybe it's wrong, it gives the impression as if you gave priority to the High Court cases than the labor court cases, but it may be that factually that's not the case.
It's not the case,
but that's the
Chief
impression
Justice.
that one gets.
Not at all. I must emphasize that the reviews were 1 or 2 a day. The reviews involve long transcripts for each case. And then at the end of the week on a Friday, there's a motion roll of 20 to 25 cases, out of which you will pick up another 1 or 2 opposed on contempts, etc. So the workload was very, very high. It was very demanding. I put in my best effort. There were times I would go without sleep in order to have the urgent orders out. Had I filed or submitted an application before I did the labor court, I would not have had this issue to have to answer to today. But it's the nature of the work in the labor court that caused me to accumulate this number of judgments. But like I said, on the other side, where I have only 10 days in which to issue the most complex awards, I've not ever had a single late award, and that could have been checked by any of the commissioners as well with the CCMA, where we have even more stringent deadlines.
Okay. I don't see any hands. Let me check the commissioners who are attending virtually. Is there any commissioner who has a question to put to the witness, to the candidate?
Questions from me, CJ?
Commissioner Barnard?
No questions?
Thank you.
No questions, thank you, Chief Justice.
Thank you, Commissioner Breitenbach.
No questions, CJ.
Thank you, Commissioner Shabangumdawe. Thank you, Commissioner Baloyi. You have a question?
Thank you, Chair. Good afternoon, ma'am.
Good afternoon, Commissioner.
Yes, I must say that I am concerned when you answer the concern that you lack experience in the way that you do, that you actually do have experience and you are good to go. Now, your experience, it has been established from your application, is largely in labor law, right? Now, that area of a law applies completely different principles of equity, right? That's what applies there. You come now to what we call court of law, which applies different principles, and one would expect that someone with your kind of background, which is steeped in the labor jurisprudence, that someone with your background will recognize that in the High Court, it's a different field, and I do require to get myself steeped in the principles that apply there, and the reasoning, the jurisprudence that apply there. And I've looked at one of your judgments, and I have put what I see as if you like, errors in reasoning, in how you express things. It's a criminal matter. You speak about beyond all doubt instead of reasonable doubt. You speak about, you don't engage contentions about circumstantial evidence in support of the state's case for pre-planned murder, I think it's a case of Nogunda or somebody like that, you don't engage those principles and concepts, and I put it down to it's a different field altogether, and I can understand how someone who's coming in on an acting basis would make these kind of errors. They are finding their way, and in good time, you will find your feet and not make these kind of common errors, what I would consider to be common errors. So I am concerned when you don't acknowledge that the periods of acting that you have had, of course, they are not sufficient to have you say, I am good to go. I don't need to do anything more. What do you say to that?
Sorry, Commissioner. I do need to learn a lot more. What I've learned when I came back to civil litigation in 2017, remember I practiced in 1996, just at the time we were getting our new democracy. I was pleasantly surprised with the changes in the law, in foreclosure, in foreclosure and all those kinds of disputes. And I voraciously read in order to reacquaint myself and to infuse into the knowledge that I had from the previous kind of law that we practiced, the values of the Constitution that are now infused in the work that we do with contracts. And yes, so for me, it was learning. I came back and I learned. I had to read a lot. I had to research a lot. And I had to prepare a lot before my cases. But I've come to a stage where I'm able to recognize immediately what the issues are. Rule 46A, immediately I know what I'm supposed to be doing. Default judgments for repossession of vehicles. I know the case authorities that must be applied and how to deal with those. So I know how to apply the law. Where my shortcomings are, I'm still prepared to research and learn. And I would love to be able to also attend such a training. I'm not saying that I know everything. I have been very upfront with my history. But I do have serious potential to be a good judge and to make a good contribution to our judiciary.
All right, thank you.
Because of the work that I've done in the past and my ability to identify what the needs and issues are in a case.
Thank you. Thank you, CJ.
Thank you, Commissioner Baloyi. Commissioner Klaba.
Yes, no, thank you very much, CJ, and good afternoon, Ms. Heralan. Observe, maybe from your presentation, you last practiced in 1996. You then rose from the CCMA to the bench, albeit on an acting basis. And in view of the comments that have been made this afternoon, I want to ask you, have you considered making yourself available for a judgeship post in the Labour Court?
Thank you, Commissioner. I know that I'm seen as that's where I belong, but my heart is in this, and that is why I have worked as hard as I have since 2017 until now to learn and to reacquaint myself with the law that I have missed out on. I've missed out on it also not through my own doing. If you look at my CV and my history, I qualified and as a conveyancer on the same day. I wrote both those exams during my articles. I envisaged a very bright future for me. And I count financial backing, having come from disadvantaged background. When Labour presented its we are. It's what I love it very much. I do my work with an absolute passion in the CCMA, and I'm recognized for that. But I'm also a lawyer. And when I came to the High Court in 2017, I spoke openly about how wonderful it has been to come back and feel like a lawyer again. And
Let me remind you to be
I've
crisp.
worked very hard. Thank you, Chief Justice. I've worked very hard, and I have learned a lot. That's not to say that I don't have more to learn, but I know where to find the law. I'm hardworking to do it.
Thank you, Commissioner Klaba. Pillay.
Thank you, Chief Justice. Can I ask you to look at the Superstar judgment? And before I pose my questions to you, I should indicate that I have a similar concern that in terms of the reason it begins at paginated page 304.
emphasized to the as points that they should particularly bear in mind when they consider your candidature. But if you feel that issues have been adequately addressed, that will be fine as well.
Thank you, Chief Justice. Just a few points. The kind of cases that I picked out for and attached to my application were meant to show that I have a certain kind of perception for people's rights, and that comes from my background in the CCMA, and for all people. The Noguda case, if you look at it, came to me as an ordinary murder case, and it took some perception to understand that it involved an LGBTQ kind of case. And it was well received by the LGBTQ community because the trial ran as if it was a murder trial, straightforward, but it recognized that there are other, I'm just trying to, can't remember which other ones there, but that's the kind of point that I was making with the judgments that I submitted. I have done a lot of judgments on contract, etc. They are there. The acting judge president would have seen my records. For me, I believe that the judiciary will benefit from my experience. I haven't had the civil litigation experience until 2017. I am teachable. SAJE is there to provide opportunities. The judiciary provides opportunities, equal opportunities. I missed out for many years because of my circumstances, and I went into work with the CCMA only, but that was not by choice. It was the kind of work I also only received. But I made a huge commitment to social justice. It is recognized in the CCMA. Even from the judgments that I wrote in the Labor Court, I sincerely apologize for not writing the case numbers, but you have my assurance that there's only 3 that are outstanding, which will go out in the next week, or at least a week to 10 days, because there are other judgments too. There are people, my judgments, when I write them, except for the mistakes that I've made that advocates for transformation have pointed out, and Commissioner Baloyi, they tend to also teach, and my Labor Court judgments have been used twice during this year by the CCMA in their monthly case law monitors, where they use it for professional development and education.
The 3 minutes is up.
Thank you.
Thank you very much.
Thank
you for availing
Thank
yourself.
you, Chief Justice.
You are now excused.
Thank you.
Should we take a break now or after the next? Now, okay. 15 minutes? Okay, let's take a break of 15 minutes. We'll be back at, okay, let's make it 25 past to be back. Yeah, okay, it's going to be a little more than 15 minutes, but it's okay. Okay, 25 past, we must be back. Thank you. Apologize on behalf of all of us that we have kept you waiting for longer than you should have.
That's understandable.
Yes. I thank you for availing yourself for consideration for appointment as a judge in the KZN Division of the High Court. We appreciate that. I'm going to ask you some questions, and after I'm done, I will ask the acting judge president to ask you questions. Thereafter, it will be the MEC who represents the Premier, and then I will allow commissioners to put questions to you. But all questions will be put to you with a view to commissioners seeing how your appointment, if you were to be appointed, would comply with the selection criteria that this body has adopted for assessing candidates for appointment. You understand that?
Yes, that's understandable.
Yes. I see that you hold 2 degrees, BA and LLB, both from the University of Natal. Is that correct?
That's correct.
And I see that you then have a diploma in theology.
That's correct.
And you are also a conveyancer.
Yes,
And you have undergone judicial skills training with the Law Society of South Africa.
yes,
And you have a certificate in insolvency that you obtained from the University of Pretoria.
yes,
You have also done divorce mediation.
that's right.
Yes. In 2014, you did an introduction to commercial law offered by the Law Society. Is that right?
That's right, Chief.
Yes, you got your BA in 1981 and your LLB in 1983.
Yes, that's correct.
Yes. But I also see that at some stage in the early 80s, you were a librarian at the University of Natal.
Beg your pardon?
Part-time.
Beg your pardon?
That I am saying, I see that in the early 80s, you were a part-time librarian at the University of Natal as well.
That's right, yes.
Yes. But you did your articles from 1983 to 1984 with Farouk Vahed and Company, and you, after your articles, you were admitted and you became a professional assistant in that firm.
That's correct.
And then you, in 1986, you established your own law firm, which you called Lang and Frank.
Yes,
Oh, you were in partnership with somebody.
yes, that's right, yes.
Yes. And you then later on became Lang, Frank, and McDonald.
That's correct.
Have you been practicing as an attorney since then, or has that changed
Yes, I have been practicing as an attorney since
then?
1985, yes.
Yes. And in 2008, you went back to, or you became a sole practitioner. You established Lang and Associates.
That's right.
Yes. And then you have written here under the chronological particulars of employment since leaving school or university, you have said name of employer, Department of Justice, position held acting judge, and then period you said in 2015 to 2021.
That's correct.
I assume that 2015 to 2021 is incorrect because probably it was different periods during that period and not continuous.
Yes, every year I think it was a session from 2015, except in 2021 there were 3 sessions that they
Yeah.
acted for.
Yes, but that doesn't mean it is continuous, does
No,
it?
no, it's not continuous.
Yes, but the way you put it here creates the impression that it was continuous.
Oh, I see, okay.
Because you said, you see, the heading of the questionnaire is, please furnish chronological particulars of employment since leaving school or university. And then you have written, and then it says name of employer, position held, and period. So you have set out names of your various employers over that period and the positions you held during that period and the periods when you were
Oh, I
employed
see.
by those employers. And then
Yes, I see that.
you have then said Department of Justice, acting judge, where it says period, you said 2015 to 2021.
Yes, it can be confusing.
That says, actually, it's not even an impression. It says from 2015 to 2021, you were employed as an acting judge,
That's,
and
no,
that's not correct.
that's not correct.
Okay. What were the periods of your acting stints?
It was in 2015. Let me just.
Or
get
maybe
to
you
that
can
one.
just say how long, how many weeks or months
Oh, it worked
in
out to about,
2015, how many weeks or months?
yes, it worked
the
out to
other
about,
years?
sorry, it worked out to about 47 weeks. It worked out to about 47 weeks,
47.
yes.
Yes. Okay. Now, tell us about the nature of your practice, the types of cases that over the years you have been doing in your practice. What types of cases have you been dealing with?
Well, initially it was mainly,
Commercial work, administrative law work, constitutional law work, labor law work, competition law work, delict, collections, aviation, patent law. What kinds of cases have you been doing?
yes, initially it started off with collection work as an article clerk, and then it moved on to delictual work, which involved motor collisions, RAF claims, including, and then went on to, we just added on family law, divorce law, and maintenance, and those sort of issues that were involved in the family. Then there was a major portion of my practice was crime, at least in the first 20 years. And as time went on, the scope grew into conveyancing, estates, because how it worked out when we formed that partnership, there were divisions. I dealt mainly with the criminal law side of it, and the other two partners had their own fields of law. But when the partnership collapsed, then what happened, everything was left on my shoulders, so I completed my conveyancing course to catch up with all the other conveyancing that was left behind, and I started doing estates, and doing family law, a lot of that, more civil work than criminal work, actually. The conveyancing was a bit limited. I wanted to get involved with insolvency as well. I did the courses with insolvency, but not much came of that. I still get appointments every now and again from the Department of Justice. I think that's about it.
Yes, I see that in the questionnaire you said that at some stage your practice consisted of 15% of criminal work, but you said you no longer do criminal work.
Not as much as I used to, yes.
Yeah, you used to. And administrative law, you said 2%. Constitutional law, 0. Labor law, 3%. Insolvency, 10%. Administration of estates, 20%. Contractual stroke commercial, 10%. Personal injury, 30%. So that's how that's the picture that emerges from your practice in the past.
That's right.
Yeah. Did you do trials, civil trials as an attorney in courts, both magistrates' courts and high court?
That's quite correct. CJ.
Do you still do them as an attorney as opposed to sitting in court as an acting judge?
Yes, I still do them. Most of my cases were done by myself as opposed to briefing counsel. Most of the size of my practice.
Do you do them in the high court as well?
That's correct.
And motion court, do you appear in the motion court
Yes, I appear
as an attorney?
In motion court regularly as well, yes.
And are there any cases that you have, in which you have been involved as an attorney that have resulted in reported judgments?
No, Chief Justice, no, nothing. There's, apart from Safley and those type of cases where they just
Yeah.
had a report, but nothing major.
Yeah. And as an acting judge, are there some judgments you have written that have been reported?
No.
Okay. About how many written judgments, more or less, have you produced as an acting judge up to now?
I didn't count, but I would assume, I was trying to work it out this afternoon, but I think it would have been about 20 to 30 at least.
About 30?
Yes.
At least. Okay. And in the High Court, when you were acting, you also sat in full bench appeals?
Not full bench, just ordinary.
You did not sit in full bench appeals?
No,
Did you do opposed and unopposed motion?
that's correct.
How much of it did you do?
Well,
Like how many weeks, for example, have been taken by motion court?
every week you sit in motion court. So not every week, it's one session. Every session you at least do one a motion court.
Yeah.
So I started doing mainly civil stints since 2018. So prior to that, I was doing mainly crime.
Yeah.
2018, 2020, 2021, I would think I would have had about 4 or 5, say 5, I think, motion court stints.
Yes. What is your understanding of what the rule of law is?
Well, I think it's there to restrict the arbitrary abuse of power by any individual. No one can, no matter what your position you hold in society, you can't take advantage of that position. So the rule of law is there to protect any other individual against that abuse of power.
And what is the doctrine of the separation of powers?
Government, I think it can be explained by saying it's the division of government into branches, which is the legislature, executive, and judiciary. And the purpose, I would think, of that division is to prevent any conflict between the three of them.
What is the independence of the judiciary?
Yes, the judges and the judiciary are independent in the sense that they cannot be influenced. They're not allowed to be influenced. They must apply the law as it stands in relation to what is presented before them. So whatever case comes before them, they must apply the law strictly as it appears in our statutes, without any favor to any particular person or organization.
Yes. Acting Judge President, I give you the opportunity to put questions to the witness, to the candidate.
Thank you, Chief Justice. Mr. Lang, I'll put some questions to you. So, according to your assessment, are you now ready for permanent appointment as a judge?
Yes, Chief.
So, on what basis to say that you are now ready?
I've had 35 years at least of practical experience. My law practice has mainly involved the application of law, sitting and acting in courts of law, involving litigation in particular. I've sat for the past approximately 7 years, I think it is, from 2015 to end of last year, as a judge, doing legal work and full-time legal work. There's been no separation or division of those periods doing something else. So I believe I'm fully qualified and have the necessary expertise to sit as a judge.
So you don't feel that you are somehow need an exposure, a further, more exposure?
No, Judge. I feel I'm fairly qualified. I may add that initially when I was asked to act, I wasn't too sure of myself. I felt intimidated. But I spoke to the leadership of my organization and they said, I must go for it.
Are you aware of the application proceedings?
Of the?
Pending application proceedings is pending against you?
Yes.
By Mr. K. Naidu and Mrs. Naidu, in which they seek an order compelling you to deliver to them an original or certified copy of the title deed in respect of an immovable property they purchased from you in 2012.
That's correct.
And the payment of the interest accrued to them before the transfer of the property in question.
Yes, I'm aware of it.
You're aware of it.
Yes.
When did you first become aware of these proceedings?
They instituted proceedings in 2021, and the sale, I was the executor in an estate, and I sold the property to them in 2012, it was.
Yes.
And
But you did not disclose them, these proceedings in your questionnaire, did you?
No, I did not.
Why not?
Well, it didn't crop my mind, actually. I didn't think it was necessary, number two. Number three is that I have other cases where I'm the plaintiff, so to speak, and those cases are mainly where it arises out of the collection procedure of debt owing to the firm, so that's where I'm the plaintiff. And there's also cases where I'm put up as the defendant or respondent in insolvency matters where I'm cited as a trustee, NO, nomine officio.
Okay, but in this application, the applicants allege that they have since 8 August 2013 been appealing to you to deliver the original or certified copy of title deed and to pay them the interest owed to them with no success.
My Lord, the position is that the title deed was delivered to them, I think, but they have no actual proof. If one looks at the document on page where it's marked served, let me get my, where the document was served on them, and then what happened was he disputed that it was served on him. So I undertook, because he's a colleague as well, I undertook that I'll apply for another copy of the title deed and deliver it to him. I prepared the papers in terms of the regulation for him to sign, for the affidavit to sign, for him to sign to suggest that the title deed was lost. He refused to sign the title deed because this was all done at my own cost. Then I prepared another affidavit suggesting that we had lost the title deed as he insisted. But he still had to sign the affidavit because it's an affidavit that he's got to put up in any event. And that's, everything just fell apart. Nothing was happening from that date. I think it was 2014 2015 or so. And only now, a year later, that's 7 or 8 years later, does he bring this application against me for for me to hand over the title deed. There's no reason for me to keep his title deed. There's nothing I can do with it. If you look at KN6 on page 51 of the papers, I'm looking at my file actually. I'm not too sure if it's 51 of his. Affidavit, the regulation provides for an affidavit to be signed in order to get a copy of the title deed. So I undertook to do that for him. The correspondence, if you read through as well, shows that I did do so. I undertook because I felt, he's a colleague, let me take the responsibility of giving him the title deed. So nothing of that was done. In dealing with the interest, I sent him the bank statements showing how the interest has arisen. And that ties in with what the money I paid him. And then he denied that I paid him. He states under oath that I didn't pay him. So I had to go and search through my archives again to find the check and the bank account to show that I paid him the interest.
Okay. Is it correct that they could not register the transfer of the property in the absence of the original or certified copy of the title deed?
Yes, you can't do that. You need a certified copy of the title deed in order to do so. So if you wanted one, you could have applied for one or insisted or asked me to continue applying and make the necessary advances to ensure that he gets the title deed.
And they further allege that at some stage you withdrew an amount of 10,000 rand from their investment account without their authority.
Commissioner, the position was that he did not pay the transfer costs. We sent him a pro forma account on the 12th of April 2012. So he received that account because he puts it up in his papers that he got that account. And that account was sent to him asking him to pay the pro forma account. Now he denies that he received the pro forma account. So what was suggested to him that we would use these monies. So those monies that were in savings were transferred from savings into a trust account to pay for the costs. So that's how it came about that the 10,000 was used. And thereafter, another 35,000 rand was transferred from savings into his trust account to pay for the other expenses. So what he didn't do, he didn't pay the pro forma account. And so it was agreed that we would use the interest from those monies to set off the payments of the pro forma costs.
So were they aware of this?
Yes, he was aware of it. Because he didn't, if he had paid the pro forma account, that would be something different. Because then I would have not taken the money without his consent. The mere fact that he did not pay the pro forma account shows that we had agreed that we could use those funds. He was also aware that the estate was bordering on insolvency. So the position was that we could not use monies that were in the estate to pay for the arrears.
So is it correct that to date we have not delivered the
title deed?
The title deed.
That's correct. I've told him in 2014 already it's lost, it's mislaid, somewhere along the line. We don't know what happened to it. Our notes suggest that it was delivered to him, and we, out of the goodness of our hearts, decided that we'll apply, and to apply for the title deed, a duplicate copy of the title deed, and he didn't bother about it. I don't know for what reason, and I thought perhaps maybe over the years that he had got someone else to attend to it.
So would you think it will be appropriate for this commission to recommend your appointment whilst you have this proceeding hanging over your head?
Yes, it is. You know, proceedings, civil proceedings in particular, I think we all face them at one stage or the other. So there should not be a bar to my appointment as a judge. The mere fact that this matter has been lying stagnant now I've just asked my attorney to find out what's going on with this matter. And nothing's been proceeded with since last year, since June, I think it was. That's the last time he put up his replying affidavit, if I'm correct. So I've asked him to have the matter sit down and finalized so that we could get this off the roll. I may also add that he in fact owes me, because that 10,000 that was paid over into the trust account, I receipted. Sorry, not I receipted, but my secretary receipted as a deposit from him. Meanwhile, it wasn't from him, it was from the savings account that was transferred into trust. So it shows it as a receipt in trust. So when the final accounts were done, I gave him credit for the 10,000 rand. With the result, I was not paid my conveyancing fee.
Okay, thank you, Chief Justice.
Thank you, AJP. Unfortunately, I couldn't hear exactly everything, and yet the issue that the AJP was asking you about seems to be quite serious. I'm just going to ask you specific questions and ask you to respond very clearly.
Certainly. I think maybe I should come closer to the mic.
Is the position that a former client of yours or somebody for whom you did some work as a conveyancer has lodged proceedings against you for you to deliver the title deed of some property?
That's correct.
And when
Chief.
were these proceedings launched?
Last year, in April 2021.
Were they by way of an application
That's correct.
in the High Court?
In the High Court, yes.
And are you opposing the application?
Yes, I've opposed the application, and he's put
You
up
file an answering affidavit,
That's right.
and pleadings have been closed.
That's correct.
And did you give them the title deed? Did you not give them the title deed?
Commissioner Chief, the position was we had delivered it. We had a note indicating that we had delivered the title deed. Served on, it doesn't say to whom, it just says it was served on him. Not on him, but it was served on the particular date.
How would it have been served? I guess you being the conveyancer, you should know to whom it was given.
Yes, it bears, it doesn't bear any signature. It shows served on the 14th of November 2013. If you look at page 113 of the bundle, you'll see there it was served on that date. Now, subsequent to that, if you look at the next page, BSL 2, I asked him to check with security to find out who came to his chambers on that day, to find out, because if in fact they came on that day, the security at Salmon Grove Chambers takes down the name of all people that come in to visit council, and would show then who dealt with the delivery of the title deed.
Who in your firm had you authorized to give the title deed to somebody? Did you authorize somebody in your law firm to give the title deed to them?
Yes, it was my secretary, has to be, who was supposed to deliver it. So it seems to be her handwriting.
Yes, but did you discover, did you not ask her whether that is her handwriting or not?
I did ask her. She confirmed, and then she wasn't too sure about it, but it was given to the messenger, she says. So from there, we had no idea where it's gone to.
So she didn't know who she gave somebody's title deed to?
Yes, she didn't know that, but normally it goes to the messenger who takes the documents to the respective parties.
So you don't know to whom it was delivered, but you are opposing the application.
I'm opposing because what I'm saying to him is that I offered to do it. I offered to get him a duplicate set of title deeds. So I didn't abstain from any form of responsibility. I took responsibility. I said, okay, fine, I accept responsibility. Let me get you another set of title deeds. It's a simple process. But he refused to sign the affidavit in terms of the regulations. So what I did, I drafted another set of regulations so that I can sign, and I took responsibility. But it still required, the regulations still require him, as the owner of the property, to sign that the title deed is missing, yes. So he refused to do that as well. So nothing was done about it from 2013 or 2014.
So is the basis of your opposition that, one, you accept that you did have their title deed with you up to a certain point, but at a certain point, your office gave it to somebody. You are not sure who it was given to, but you have offered as an alternative, you offered to obtain a duplicate title deed for
That's
them
correct.
at your own cost.
That's correct.
But in order for you to do that, you needed them to sign an affidavit because that's what the regulations required.
That's quite correct.
And they refused.
That's correct, Chief.
Okay, all right.
And then he refused initially because I wanted him to say he lost it, you see. Then,
Why did you want them to say they lost it if you
Because-
didn't know whether they got it?
well, that's what the regulations provide for. So then what I did, I changed the
They
affidavit.
can't say they lost it if they,
Well, you
they
worded-
didn't lose it.
Well, that's what the regulations prescribe. It prescribes that only the owner can apply. Okay?
Yeah,
So then the owner
okay.
must sign the affidavit in any event. So what
Okay,
I
all
did
right.
subsequent, a couple of days later or whatever.
Yeah, no, that's fine. MEC?
Just one question, CJ.
Yes.
When the CJ posed a question on the rule of law, your understanding on the rule of law, you said it seeks to limit the abuse of power and people not to abuse the offices that they occupy, which I find to be very limited understanding of the rule of law. Now, what is your understanding of the relationship between law and justice?
Well, law is what is on the statute books. Justice defines how you impose that law. So if in fact we have a law that's on our statutes, that's one thing. Justice is to ensure that the law is followed. And the forum in which that is ensured is the courts of law.
Thanks, CJ.
Thank you, MEC. Commissioner Matolo Tlepu.
Thank you, thank you, Chief Justice, and good afternoon, Mr. Lane. What I want to understand, were you the executor in this property or in this estate?
Yes, I was the executor.
And has the transfer been effected already?
Yes, the transfer was fixed in 2013, yes.
Into his favor?
Into his favor, yes.
Oh, okay, thanks.
Thank you, Commissioner. Justice Betze.
Thank you, Chief Justice. Mr. Lang, speaking for myself, I understand your explanation in relation to the lost title deed and what you propose to do in order to apply for a certified copy. But in the founding affidavit by the Naidus,
Yes.
they make allegations of, in effect, impropriety against you in that, in effect, you help yourselves to monies standing to their credit in their trust account without them authorizing you to do so. And in effect, or as a result, they lost out on interest that they would have earned eventually. Do you think that it would then be a wise thing on the part of the Commission to recommend you whilst these proceedings are pending?
Commissioner,
Before you respond, let me
Yes.
just add this. From the explanation you gave earlier
Yes.
about how it came about, I didn't hear you saying, maybe I missed something, but I didn't hear you saying they had given consent. It came across as if you helped yourself to their money because you thought there was justification because they owed you and they had not paid the pro forma account.
No.
That's the impression I got of what you were saying.
No, it's in these papers as well, Chief Justice, that they had given me consent. And I explained it by them not paying the pro forma account shows that they had consented to me using their money for those purposes, because in a conveyancing matter, there are expenses to be met. And those expenses have to come from somewhere. In particular, the rates. The rates had accumulated quite a bit. So there are expenses that have to be made, and we normally give a pro forma account to the purchaser for him to pay. So the purchaser, Mr. Naidu, never ever paid that pro forma account. And that shows and adds credence to the fact that he gave me permission to use the money in his, that was in trust for those purposes. The money didn't come to me, by the way.
A follow-up, Mr. Lane. In paragraph 9.3, they make the categorical averment under oath that you withdrew a sum of 10,000, whereas the respondent was not entitled to make such a withdrawal, as we had not given our authority
Yes,
for such withdrawal to be made.
yes. There was no written authority. He's a colleague of mine. I did this work for him. I even gave him the opportunity to pull out the sale if he wanted to, but he was desperate for the sale, and he knew that we had no monies available. And that's why I don't know the reason why he brings it up only now since I've applied for this position. But he had all these years in which to do it. Nothing was done.
Hang on, Mr. Lane. Did he give you consent?
Yes, he gave me consent.
Was it written?
No, it was not written.
Was it verbal?
It's verbal.
That you can take out that money from the savings to the
Trust.
trust?
Yes.
So why do you think he's saying now he never gave you consent?
Chief, I just don't understand what his whole motive is in this whole case. If you read through all the papers, you would see, if you looked at my defense as well, you would see what's going on. I have my personal views, but I won't mention them now about him. I've never ever briefed him before. I've never had any relationship with him before. This was the only incident.
Did you say earlier on, because I seem to hear you to have said, by not paying the pro forma account,
Yes.
he gave you consent?
No, no.
Did you say something like that?
No, I said it that by him not paying the pro forma account shows that he consented. I'm just using that as proof to suggest that he had consented to me using the funds to pay for those expenses. Where else would the funds come from except from him?
So is it his failure to pay the pro forma account that you rely on to say he consented?
No, I'm just relying on that as proof that he had consented.
So when had he consented?
Well, it was around that time when we had to pay for expenses. That's why we drew the account, the monies from the savings account into the trust. There's no other reason for that.
Mr. Lang, if I were in your position, in that situation, I would have said to the Naidus, there's no way that we can attend to the registration of this transfer because the fees that you are supposed to pay as per the pro forma statement sent to you on date X has not been settled. And if need be, then you would have, if the deed of sale or agreement of sale make provision for cancellation of the agreement upon breach thereof, you would have given him notice to say, if this doesn't happen, this is the clause that you would invoke to cancel the agreement and hold him liable for whatever damages had been suffered, instead of you helping yourself to those funds because he hadn't paid.
Yes.
He makes this categorical affirmation,
Yes, I
and
think,
the matter is pending before court. And you ask why he is bringing this only now. And yet these proceedings, on your own account, was instituted on the 21st of April, 2021, long before this position was advertised.
yes.
And the Secretariat of the Judicial Service Commissions, once nominations were made and accepted, invited interested parties who wished to comment or lodge objection to do so. And this is how it came about that we have this document before us today. Thank you.
Thank you. I guess you have said what you wanted to say, Mr. Lane.
Yes, I think, well, if you look at the papers itself as well, and you look at my answering affidavit, you will see the history of the matter. I mean, first he accused me of not paying him at all. He makes a statement that I didn't pay him his interest.
Well, the point that Justice Betze is raising, and I think somebody else may have mentioned, I think the AJP is, it may be risky for this commission to recommend your appointment when there is this litigation pending where allegations are made, such as those that are made, in case the matter ends up with some adverse findings against you, it might not be prudent for the commission to go that route. That's what he's raising with you, and that is what the AJP was raising with you, to say, don't you think that you should have that litigation behind you before you can come before this body and ask to be appointed as a judge?
Yes, no, that's understandable. But, it's become a bit personal, I think, and it was raised at the time when I appeared before you on the last occasion in April 2021, and that's the time those proceedings started. And so I think it's
But
become personal.
you understand that the point being made is there might well be a risk in recommending your appointment in case that litigation with those types of allegations of impropriety against you turn out to be upheld by the court when you are already a judge. Is it not safer for this body to say to you, or for you to say, I would rather go and sort out my matters and I will come back later should I decide to come back when there is no litigation hanging over my head?
Well, I think in all fairness, perhaps maybe if everyone could just read those papers and look at my defense and look at the reply, as long-winded as they are, not my reply, but the applicants.
Yeah, but I'm not saying you must take a particular decision. I'm just saying this is the essence of the concern that is being raised. Okay?
Fine.
All right. There was Commissioner Singh. Had I given you a chance? Okay.
No, thank you very much.
Then I've got Commissioner Tsepe and Commissioner Klaba, and I think I would like to then go after that to the commissioners attending virtually and close. Commissioner Singh.
Thank you. Mr. Lane, you haven't responded to the proposition by the Chief Justice, and I don't know if you want to remain silent on it or
Yes,
the proposition that you should consider, Would you like to offer a comment on that?
Well, that's
first
why I
before-
suggested perhaps maybe, a brief perusal of the papers may show the validity of my defense. That's all I can say, but I suppose with proceedings pending, it's not fair to the judiciary to have those proceedings pending against a judge that's appointed. But in the same breath, there's also other cases, so I don't know how to explain these things.
I guess, Commissioner
Okay.
Singh, that's the answer.
Okay, thank you
Yeah.
very much, Chief Justice. I'll then proceed with my question. I really thought people of the same ilk would find each other, and through arbitration and through settlement, etc. But I'm quite surprised. In fact, I think the acting JP, I was going to raise this matter, but he canvassed it very, very widely, so that's good. I just want to refer to Mr. Lang, your questionnaire and section 2 in particular. Legal background. That's on page 6 or 8, whichever way you want to look at it. And read that with 625, where you say that 10% of your work, litigation work, is family law and divorce.
Okay, what paragraph is that one?
625
Okay, sorry, I'm looking at the wrong.
in your questionnaire. You state that 10% of your litigation work is family law and
Sorry,
divorce.
that's the wrong one again. 625.
Yeah, 6.2.5.
62.5 or was it
No,
600?
6.2.5, and it will be on page,
Paginated 12.
yeah, that's a word I was looking for, Commissioner. Your lawyers use that word. I would have said 10, page 10. Have you found that?
Oh, this is Harilal. I think this relates to Harilal.
In any case, but that's what's written there. So you've said 10% of your litigation work. But then on paginated, now a new word, paginated 9, Roman numeral 4. I don't know if you've got
Okay, let me look at my bundle rather to prevent any confusion. Okay, on the questionnaire,
Yes.
paragraph.
Paginated 9, Roman numeral 4.
Okay, no, thank you. Yes.
You've stated something there, and I just want to know before I remind you what you stated, whether this is a personal view, a religious view, or a legal view,
Yes.
where you say in the last 10 years I've shifted my focus towards civil litigation and family law. I believe that stable families make up stable communities.
Yes.
I am concerned about the breakdown of relationships and the ease with which divorces are granted. A more conservative approach should be taken in the granting of divorces.
Yes.
Now, I would take it you get a number of divorce applications before you, and there are circumstances like unhappy marriages, abuse, and things like that warrant divorces.
Yes.
I'm just trying to understand what you say here, that a more conservative approach should be taken in the granting of divorces.
Well, the test is whether the marriage is irretrievably broken down. Okay? And it's very easy to grant a divorce. There's two aspects to it. The one is from the judge's point of view, and the other from the attorney who's acting in the matter's point of view. So I'm suggesting that because we need a society that's stable, if you have a society that's broken down by the separation of mothers and fathers, you have a society that's ungodly society, if I may say that. You have a society that's a confused society. You have a society where children
Sorry, I
have
didn't hear the word before. Ungodly, you said.
Yes.
Ungodly society.
Yes. Marriage, where there are marriages, a society is stable because there's a family structure in place. Where there's been an abandonment of responsibility, either by the mother or the father, you find there's conflict. You find the children go astray, and with the result, it affects the community. So the stability of any community depends on the strength of the family in that community. That's my personal belief. So it's important to protect families. It's too easy nowadays to get a divorce. From a judge's point of view, it's granted easily without them without some investigation being taken place into reasonable prospects of reconciliation. So I'm of the view that there should be some attempt to try and keep the family together.
No, I certainly agree with you about family values, just as of family values and keeping families together. But I was surprised that this kind of comment comes from a person who's applied for a judgeship. So when I read that, it just rang a bell. Thank you. Thank you, Chief Justice.
Thank you. Commissioner Tsepe, I've got Commissioner Klaba and Commissioner Nochesi, and after that I would like to stop and look at the commissioners who are attending virtually, and let's see if we can wrap up. Commissioner Tsepe.
Chief Justice, you'll be happy to know that Commissioner Singh raised the issue I wanted to raise about this issue. But I just want to say, I'm still not sure what a conservative approach in a constitutional democracy means.
Yes.
And it does concern me, Chief
Yes.
Justice. I've heard Mr. Lane's answer, but it still concerns
Yes,
me. And I'll
but
leave it there.
he has given his response, yeah. Okay. Commissioner Klaba?
CJ, I'm also on the same question.
Yes.
I mean, the question, does this not create a reasonable apprehension that you may be biased against the litigants in a divorce application?
No, actually, on the contrary.
Thanks.
I think on the contrary, I think I'll be helping them to solve their problems. Because if you, as the presiding officer in a potential divorce matter,
Well, I'm sorry, Commissioner Klaba, I wonder whether you expect a different answer from the one he gave to Commissioner Singh.
Maybe let's leave it at that.
Yeah, he has given a
CJ.
certain
Thank you for
answer.
your guidance.
It might or might not satisfy, but that's his answer. Commissioner Nochesi?
I've also been covered by...
Oh, you have been covered. Commissioners attending virtually, is there anyone who has a question? No one.
None from me, CJ.
Thank you.
I have no questions. Thank you, Chief Justice.
Thank you, Commissioner Breitenbach. Thank you, Commissioner Barnard. Thank you.
He's listening.
No. I said no questions from me, Chief
Oh,
Justice.
okay, all right. Okay, all right. Thank you, Mr. Lang. We have come to the end of the interview. We thank you for availing yourself. I'll give you 3 minutes for you to emphasize any points, any 2 or 3 points that you might wish to emphasize, that you think the commissioners should particularly pay attention to when they consider your candidature. But it's fine also if you consider that important issues have been dealt with adequately.
Yes, perhaps I should just say I want to thank the Lord Jesus Christ for giving me an opportunity to appear before this esteemed commission and in order for an opportunity to serve my country. And secondly, perhaps I would like my God to bless you with wisdom and direction in your endeavors to protect our judiciary. Thank you.
Thank you very much.
Thank you.
Thank you, Mr. Lang.
Thank you.
You are now excused.
Thank you. Can I have a sweet?
Thank you.
I have 2.
Yeah, sure. No, yeah, look. Yeah. Yeah. Are they fetching the candidate? Oh, okay. Is at the door, so they must bring him in. Good afternoon, Professor Matenjwa.
Good afternoon, Chief Justice and Commissioners.
How are you this evening?
I'm well, thank you, Chief Justice.
All right. I apologize on behalf of everybody that we have kept you waiting for much longer than you should have. But you are here now and we'll give you an opportunity to impress us. I'm going to ask you some questions, and then the acting judge president will ask you questions. And then the MEC, who represents the premier, will also ask you questions. And then commissioners who have questions for you will ask you questions as well. But we thank you for availing yourself for consideration for appointment as a judge of the KZN Division of the High Court. In terms of your qualifications, I see that you have a B.Juris degree, which you got from the University of Fort Hare in 1991, and you have an LLB degree, which you got from at the University of Wits in 1996, and you have an LLM degree which you got from UNISA in 2007, and you have an LLD which you got from UNISA in 2014.
That's correct, Chief Justice.
And you are a professor at UNISA.
I was a professor, Chief Justice. Yes, I'm still a professor, but I'm no longer attached at UNISA. I took early retirement last year, Chief Justice.
Oh, you don't look like somebody who should be going to retirement.
No, Chief Justice, it's because I wanted to take full-time practice. Now I'm practicing full-time as an advocate in Bishop Chambers, Johannesburg.
Oh, well, I see that you did your articles of clerkship with Cox and Partners attorneys in Vryheid.
Correct, Chief Justice.
From 1996 to 1998.
Correct, Chief Justice.
But prior to that, you had worked as a constable in the South African Railways Police Force in Mpangeni.
Correct, Chief Justice.
In 1982 to 1985. From 1982 April to December 1985.
That's correct, Chief Justice.
And then you were promoted to the position of sergeant in the same force, but now you are in Vryheid from 1986 January to December 1986.
Correct, Chief Justice.
Oh no, I see you went up to 1988. And you were admitted as an attorney in 1998?
Correct, Chief Justice.
And for how long did you practice as an attorney?
I practiced as an attorney for 4.5 years, Chief Justice.
Yes. Was that all for your own account or with somebody else?
I first practiced as a professional assistant with Bothas Incorporated, and thereafter I practiced on my own account at Mpangeni, Chief Justice.
Yes. And Then you were employed as the head of the Department of Safety and Community Liaison in the KZN provincial government
Correct,
from 2002 July to June 2004. Is that right?
That's correct, Chief Justice.
Later on, you worked for the Mandeni municipality as a municipal manager from
Correct,
July
Chief Justice.
2004 to July 2006.
That's correct, Chief Justice.
Then in 2010, you started lecturing at Northwest University as a senior lecturer.
That's correct, Chief
And
Justice.
and in 2011, you went to UNISA as a senior lecturer. In 2016, they made you associate professor. And in 2018, they made you full professor. And you were a full professor at UNISA up to March 2021.
That's correct, Chief Justice.
And I see that thereafter, it reflects that you are self-employed as an advocate of the High Court with effect from 1 April 2021 to the present.
That's correct, Chief Justice.
But it doesn't say when you were admitted. When were you admitted as an advocate?
I was admitted in 2019, Chief Justice.
In 2019?
Yes.
Was that after doing pupillage or not?
Chief Justice, I was admitted while I was doing pupillage at the Pretoria Bar.
Oh, so you did your pupillage at the Pretoria Bar?
That's correct, Chief Justice.
Okay, which year was that?
I took research and development leave and did pupillage in 2019, Chief
Yeah.
Justice.
So the pupillage you did in 2019?
Yes, Chief Justice.
Oh, okay, and then you started, so after your pupillage, you only started practicing in 2021?
Chief Justice, after my pupillage, I went back to the university. I served 1 year, and then I practiced as an associate of the Pretoria Bar in 2020. Then in 2021, I started practicing as a full member of Johannesburg Bar.
So your practical experience as a lawyer consists of the time you were doing articles. Maybe we shouldn't even count that. After admission consists of 4 years, because I think you said you practiced for 4 years or 4.5 years, I'm not sure.
4.5 years.
4.5 years,
Yes.
plus the time from April 2021 to the present.
Yes, Chief Justice.
So your practical experience is 4.5 years plus 1 year. So it's about 5.5 years.
Yes, Chief Justice.
That's the sum total of your practical experience.
My practical experience, that's correct, Chief Justice.
Yes. Okay. And have you acted in the High Court?
Yes, Chief Justice, I've acted for 15 weeks in civil court and 10 weeks in criminal court.
Yes. And so I guess with the limited practical experience that you have had as a practitioner, there would not be any reported cases in which you appeared. Is that correct?
It's correct, Chief Justice.
And with regard to that period, did you do trials, civil trials, criminal trials as an attorney and as an advocate?
Yes, Chief Justice. While I was an attorney, mostly my work was a criminal trial, but I've also done a civil trial.
I guess when you say most was criminal trial,
Yes.
it must mean that there was limited civil trials.
The
Civil
huge
trial
bulk of
work.
it, yes, is correct, Chief Justice.
Yes. And since April 2021, How many civil trials have you done as an advocate?
Well, Chief Justice, as an advocate, most of my work, it's a legal opinion.
Yes.
Because of my expertise, I give a lot of legal opinion.
Yes, okay. So you haven't done any civil trials or criminal trials since April, after you started your practice in April 2021?
Occasional motion court, Chief Justice.
Okay, so with motion court, it's even occasional, even with motion
It's
court.
occasional, because I started last year, Chief Justice.
Yes. And, but why would you think that with this limited practical exposure that you have had, would you think that you are ready to be considered for appointment as a judge?
It's because, Chief Justice, in the new democratic dispensation, the pool from where judges are taken from is a blended pool, that of academics and attorneys and advocate. So my submission is that my experience as an academic, senior academic, combined with that limited experience as an attorney and an advocate should count to my favor.
But when you are a judge, you deal with practical cases, and it's important for this body that if it recommends or advises the president to appoint somebody as a judge, particularly at high court level, that this body should be confident that that candidate, once he or she starts as a judge, will know what to do to run trials, do motion courts, and so on. That doesn't mean that if you have an academic background, you can't be considered. But it might depend how much acting you have had, because that helps, particularly when you are competing against some of the candidates who might have a lot of experience with what a judge does. So one does not necessarily talk about exclusion, but it's just that when you are competing against people who have a lot of experience, it might not be easy. Not that it can't be done, it might not be easy. Indeed, there are academics that this body has recommended be appointed, but as far as I know, at least in the High Court, those were candidates where this body was satisfied that they have had sufficient exposure. Or I guess maybe you say the weeks that you are talking about of acting are sufficient.
Chief Justice, I will say that without dictating to the Commission, Chief Justice, but the experience that one gets as a senior academic of interpreting and applying the law, it's just the same, actually, because even when you are a judge, you have to interpret and apply the law. So with regard to the exposure, Chief Justice, I'll say that will be a relative term, because what might be 60 weeks to another person will be sufficient for 20 weeks to another person.
Yes, okay. So how many written judgments have you produced as an acting judge?
I've written 23.
23 judgments.
Yes.
Okay. And what branches of law do they relate to?
They relate to commercial law, like passing off, delete, like medical negligence, Rule 43, contract, divorce, agent applications, interdict. So far, contract, Chief Justice.
Yes. Have you sat in motion court during your acting stint?
Yes, Justice, every Thursday I was in motion court. Therefore, the 15 weeks that I acted, then I'll have been in motion court for 15 days.
Yeah. And civil trials and criminal trials you have done?
I've done civil trial, criminal trial.
About how many civil trials and how many criminal trials? More or less.
Chief Justice, the 23 that I spoke about was civil trial. So with regard to criminal trial, I happen to be allocated a very long criminal trial, which took the whole 10 weeks, the whole terms, the whole term.
Yeah, so how many civil trials, or is that to say one civil trial, or what is that to say? I just want to have an idea how many civil trials you have done, how many criminal trials.
Civil trials, Chief Justice, if I remember very well, they could be 6.
6.
Yeah.
And criminal trials?
Criminal trial, I've been involved in that one long criminal trial.
One long criminal trial.
Yes.
Okay. What is your understanding of the rule of law?
The rule of law, Chief Justice, firstly entails that whoever exercises public power must be authorized to exercise such power. Secondly, it entails that the exercise of public power should be within the limit of that authority. Thirdly, it entails that all people are equal before the law, regardless of their status.
Yes, and the doctrine of separation of powers?
If Justice, the doctrine of separation of powers addresses the issue of concentration of power to one body or one institution, which then may lead to abuse of that power. Therefore, the doctrine of separation of power have 4 components. Firstly, is the separation of the 3 branches of government. Then secondly, is the separation of functions within the 3 branches of government. Thirdly, is the separation of the personnel itself. And the 4th element is the check and balances, which then enables each branch of government to check the other branch of government. But basically, the basic meaning is that each branch of government should not intrude on the terrain of another branch of government. But that is qualified by the 4th requirement of check and balances, like what I'm doing here today. The legislature and the executive are doing the check and balances on the appointment of a judge.
Mm-hmm. And the independence of the judiciary?
The independence of the judiciary, Chief Justice, entails 2 elements. Firstly, it will be institutional independence, that the judiciary should be independent from the other spheres of government. Second part will be the personal independence of a judge. Then the personal independence of a judge will then require a judge, when presiding over cases, not to be influenced by his political commitment or religious views
Yes. Thank you. I will now give the acting judge president the opportunity to put questions to the candidate.
Professor Matenjwa.
Good afternoon, Acting Judge President.
Yes. So just put few questions to you. Abt is of the view that you have not demonstrated the abilities.
Please raise your voice or speak up, AJP, please, so that we can hear.
Abt is of the view that you have not demonstrated the abilities and experience of a High Court judge. Do you have anything to say in this regard?
Yes, Chief Justice. Firstly, when they made this comment, it was based on my limited experience of 15 months, but thereafter, 15 weeks. But thereafter, I was then afforded that 10 weeks more. On the issue of displaying that experience, Acting Judge President, it will be, in my view, it will be more adequate for me to respond if they were able to specify, to be specific, either from my cases or from any day where I displayed that kind of inexperience.
Okay, it further suggests that you require to develop further experience in the High Court.
Yes, Acting Judge President, that view speaks to the explanation that I've already given, that the new dispensation created that blended system of drawing judges from academics. Definitely because of my situation as an academic, I will have limited court experience as compared to advocates and attorneys who are practicing full-time.
So in the light of limited court experience, don't you think that you need further exposure?
Chief Justice, that is in the Acting Judge President, that is in the hands of the Commission. But in my view, I have displayed the potential because, just to mention, for instance, in this last quarter, I have to deal with 12 appeal from the Magistrates Court. And out of these 12 appeals, I delivered 4 judgments extempore, like senior judges. And even the bail appeal that I received, I delivered it extempore. So the pace and that I've displayed shows that, in my view, I'm ready. And if not ready, of course, I cannot be 100% ready, but I have the potential.
So on the other hand, GCP states that you align yourself with fairness and social justice in the administration of justice.
Sorry?
The GCB states that you align yourself with fairness and social justice in the administration of justice, and it also goes on to state that your appointment will strengthen the High Court with both your breadth of legal knowledge and experience and your academic background. Do you have anything to say in this regard?
I appreciate that comment, Chief Justice. Acting Judge President.
Thank you, Chief Justice.
Thank you. MEC?
No questions, CJ, thanks.
Thank you. Commissioner Singh?
Thank you very much, Chief Justice, and good evening, Professor Matendra.
Good evening, Commissioner.
I must first make a declaration, Honorable Chief Justice and colleagues, and one has to look at paginated 9, Commissioner Boloy, question 8, to find that answer of the association between Professor Matendra and myself. I haven't seen him in a number of years. Now, I've known him to be an activist in the community and an expert in local government. But I'd just like to ask you, Professor, what motivated you recently to leave academia and and join the bar?
I think I've done well in academia. I've achieved the upper echelon in academia, and I have now felt that I should be involved in practice. I like practice.
And how is the practice going in the short term?
Well, in the short term, Commissioner, because of this COVID, things will not have run the way I would have liked them to go. But I'm getting there.
Thank you, Chief Justice. Thank you, Professor.
Thank you, Commissioner Singh. Commissioner Nochesi?
Thank you, CJ. Professor Matendra, I just read from the LSA, the Law Society of South Africa. They say the LSSA believes that his wide range of experience would be beneficial to the judiciary and support his application for appointment to the bench. Now, my point here is, I recall Judge Hlophe, one of the best judges in the country, moved straight from the University of Transkei and became a judge. How beneficial it is to have somebody with your background as an academic who joins the bench in terms of capacity of research and scholarly judgment that my professor here would like to insist on.
Thank you, Commissioner. I think it's very beneficial because I will say right now what I've displayed in that court, no one can say I've come to ask. I'm able to run on my own. Why? Because I'm able to do research. Whenever I find problem or challenge, I always have my laptop. Then I'll go to my laptop, look at that particular topic, and then I get the answer. So I think it's very beneficial not that I'm promoting academics, but it's very beneficial because then they are able also to conduct research. And for me, in my view, is also coupled with that little experience as an attorney and also as an advocate.
Thank you, Chief Justice.
Thank you. Commissioner Nyambi?
I'm fine, CJ.
Oh, okay. Why did I think you raised your hand? Okay. Commissioner Totovu?
Thank you, CJ. Good evening, Prof.
Good evening, Commissioner.
As an academic, you teach at undergraduate or postgraduate level?
Commissioner, I teach in both. Because,
in both?
Yes.
Okay. The caliber of students that you teach, do they include advocates, prosecutors, and judges? Because I see most of them lately are studying.
For now, especially with regard to supervision, without naming, yes, with regard to supervision, because I supervise doctoral students and master students, definitely there will be judges and director generals and everyone.
Thank you very much, CJ.
Thank you. I didn't see any other hand. Or Commissioner Moimang? And, yeah,
Thank you,
after that, I'll go to the ones attending virtually.
thank you, Chief Justice. Good evening, Prof.
Good evening, Commissioner.
Just one question from my side. What is your understanding of the normative constitutional theory in relation to the assessment of the judicial behavior, but taking into account the liberal legalist and also the critical legal theorist? I'm raising this taking from your LLM thesis. Thank you.
My apology, Commissioner. From my LLM thesis, I did not deal with that. My LLM was on a fundamental right, and my doctoral was on multi-level governance. So I do not have that in my LLM thesis.
Thank you, Chief Justice. Maybe what we could do, just pay visit to a book by Rooks in his assessment of the first 10 years of the work of the Constitutional Court.
No, I haven't looked at that.
Thank you. Pay visit to it. Thank you.
Thank
you, Chief Justice.
Where is that voice? Oh, you are done. Okay, thank you.
I'm done, Chief Justice. Thank you.
Okay, all right. Commissioners attending virtually, is there anyone who has a question for the candidate?
I have no questions. Thank you, Chief Justice.
Thank you, Commissioner Breitenbach.
No questions from my side, Jane.
Thank you, Commissioner Shabangu Mdawe.
Chief Justice, I have a question or two.
Okay, all right. One.
Chief Justice.
Only one.
All right. The case on customary marriages, the Mashengu versus Mashengu and others. In that case, the heading says that the first respondent is Estate Late Mashengu and others, which is something I'm not sure I understand who exactly that first respondent is. But that's in passing by. I just want to make sure that on the enforceability of this order, where it refers to the applicant is entitled to, perhaps if you can just indicate, is the applicant entitled to anything in terms of this order? And is it enforceable? I think I'll leave the question at that then. You can perhaps just comment on that in the context of customary marriages. Thank you.
Thank you, Commissioner. The position with this case is that the applicant's view was that she was entitled to the half share of the estate. So because there was no evidence then led as to, because if you follow the case very well, I indicated that in terms of the new customary law that came into effect on the 1st of June 2001, that system created a different proprietary system. Firstly, that if the couples were married, then they will share, the husband and wife will share from the property in that wife household. And there will be a property that does not belong to any of the household. Then all wives and husband will share equally to that property. And there'll be a property that that is exclusive property of the spouse. So what then I said there was that because there was no evidence that there was property, I said if it's any property that does not belong to any of the household, then each party, because there were 3, is entitled to 1/3 of that property. If there was any property that belonged to the wife and the deceased household, each party then will have to share half of that. That was the essence of the judgment, based on the interpretation of the customary law that came into effect on the 1st of June 2021.
Well, I'm limited to one question, so I can't go on further than that. Thank you, Chief Justice.
Be nice to you. Just one more, and that's it.
Well, it just seems to me that you're applying the law to no facts. So it's like saying to a litigant, you are successful, maybe. I'm not sure if I'm misunderstanding the order, Professor.
But Commissioner, there are facts. The facts are that, 1, the applicant was married to the deceased. All what they wanted to know is what share do they have, and that's it. And then I gave judgment according to their request that your share is 1/3 of this, and your share is half of that.
Thank you, Chief Justice.
Thank you. I think we have come to the end of this interview. Thank you very much, Professor Matendra. Thank you for availing yourself for consideration for appointment as a judge of the KZN Division of the High Court. I will give you now 3 minutes to emphasize 2 or 3 points that you would like the commissioners to bear in mind when they consider your candidature. But if you are happy that all issues have been adequately dealt with, that will also be fine.
Thank you, Chief Justice. Mine is to thank the Chief Justice and the Commissioner for enabling me to express myself before this commission. Thank you for that.
Thank you very much. You are now excused.
Thank you, Chief Justice.
Thank you.
Thank you.
Good evening, Mr. Mossop.
Good evening, Chief Justice. How are you
Did I
doing?
pronounce your surname correctly?
You did.
Thank you very much. How are you this evening?
Chief Justice, I'm fine. I hope you are well as well.
Yeah, we are fine, thank you. We apologize that we have had to wait for quite some time. But you are here now. You will get a chance to impress the commissioners.
Thank you very much.
I'm going to start off by thanking you for making yourself available for consideration for appointment as a judge of the KZN Division of the High Court. And I'm going to ask you questions up to a certain point, whereafter I will then hand over to, or rather allow the AJP to ask you questions. After that, I will ask the MEC, who is representing the Premier, to ask you questions, and after that, I will allow commissioners, those commissioners who may have questions for you, to ask you questions.
Understood.
I see that you hold the degrees of BA and LLB, which you obtained from the University of Natal. Is that correct?
That is correct.
And you obtained your BA in 1981.
That is correct.
And your LLB in 1984.
Correct.
So it looks like I came to the University of Natal just 1 year after you had completed your LLB.
I'm sorry we missed each other.
But I think when you were doing your last year LLB, the acting judge president of the KZN division was doing his first year in LLB, postgraduate LLB, as well as the former Chief Justice.
Yes, they were together.
So you may have seen them then. I see that you served articles from 1987 to 1988, and you worked as a professional assistant in 1989 in a law firm called Thorpe & Hens, and that's where you had done your articles too. And then in 1989 to 1990, during that time, you were a legal advisor. You were a legal advisor at Altron Corporation. You became a prosecutor in the district court in 1990, regional court prosecutor in 1990 to 1991. You became a magistrate, district criminal court magistrate from August 1991 to December 1995. And then in 96, you started your pupillage in January, and you started your practice as an advocate on 1 July 1996.
That is all correct.
And you went on, and then in December 2015, you obtained, you got silk, and you have continued to practice as an advocate throughout, up to date.
That is so.
So that means you have been practicing as an advocate for how long?
I'm in my 26th year.
About 26 years?
That is so.
Yes. And about 7 of those years as silk?
That is so.
Yes. Tell us about your practice over the years. What kind of branches of law, do the cases that you do in your practice relate to?
So, Chief Justice, you will have seen that I've had experience in most sectors of the law, but probably for the last 15 to 20 years, my practice has been largely a commercial practice. And that flows from my employment, I guess, as a legal advisor in Johannesburg for the Altron Corporation. It was, excuse me, it was one of the biggest groups of companies in the country at that stage. There were over 100 companies in the group, and there were only 2 legal advisors. So we did basically everything that you could think of when it came to commercial law. Advising on law, drawing agreements, and being involved in corporate mergers and corporate takeovers. So that stood me in good stead for when I eventually went to the bar. And I initially had a practice that reflected my immediate origins, which was in the criminal courts in Durban. So I did criminal work for 3 or 4, maybe 5 years, and then I kicked into a commercial practice, which I've maintained ever since. So I do all sorts of corporate commercial matters, company disputes, shareholders disputes, Anton Pillow orders, interdicts, restraints of trade. I appear in commercial arbitrations where the numbers that are involved are mind-boggling. And I've sat as arbitrator in commercial disputes, and the last one involved the Petroleum Products Act. So I've had basically a very strong commercial and corporate background to date.
And have you got administrative law cases that you do in your practice?
I do. I often litigate against the Department of Trade and Industry in Pretoria over incentive programs that they run for industries that are encouraged to set up their businesses in less populated areas as a method of securing employment in the area. So I often act for those companies where they indicate that they've been badly treated by the DTI.
And constitutional law?
I've never appeared in the Constitutional Court, but Chief Justice, to be honest, isn't every single case that we deal with a constitutional case? The Constitution is everywhere, and it must be adhered to, and you must always have reference to it. You'll see that 2 of the judgments that are submitted in support of the nomination have references to the Constitution, which is everywhere. It's endemic.
Yes. And labor?
I've appeared in the Labour Court once or twice, but it's not a strong point of mine, Chief Justice, unlike you.
And competition law?
No, I've never appeared in the Competition Court.
Okay, all right. About how many cases in which you have appeared that have resulted in reported judgments, if any, if there are any?
No, there are, but I regret that, Chief Justice, I'm mostly on the losing side in those cases that find their way into the law reports. I think there are about 8 or 9, but I can't be certain.
About 89 or so?
Or 8 or 9.
8 or 9?
Yes.
Oh, okay, okay.
Yeah, I don't have a good record in the books.
Yeah. And how long have you acted? If you put your acting stints all together, how many months or weeks would that be?
42 weeks and 4 days.
And 4 days?
Yeah.
All in the KZN division?
Yes. Some in Durban, and then mostly in 2021 in Pietermaritzburg.
Yes. And are there any reported judgments that you have written during your acting stints that have ended up being reported?
Not in the SA law reports.
Yeah.
I mentioned in my application that a lot of my judgments have appeared in these daily news reports that come out, LexisNexis and Louis' Law and that stuff. But nothing in the law reports. And I think, I'm not saying that any of my judgments are worthy of being in the law reports, but when you go to act, you aren't told how a law report gets your judgment. So I didn't know how to get anything onto SAFLI.
Yeah.
And eventually, towards the end of last year, it was revealed to me how it's done, but you don't get told these things, so that may explain it.
Now, during your acting stints, have you been involved in full bench appeals?
I have. I've sat in 3.
And have you conducted criminal trials and civil trials?
I have. In the last session, I did a criminal trial that lasted a month.
And you have done motion court opposed and unopposed?
Absolutely. It's the best part of being a judge, I think,
Yes.
is being in motion court.
Yes. What is your understanding of the rule of law?
Well, it's a political concept that everyone in a state, both citizens and institutions, are all subject to the same law. It has its origins, if I can remember correctly, in the 16th century Britain, and it was basically brought to light in a big way in the 17th century when it was used to combat the king's assertion that he had a divine right to rule. But from what I've read and understood about it, it may conceivably go back to the time of Aristotle, where he expressed certain views about laws ruling and not people. And it's intended to ensure that everyone suffers the same consequences under the same law.
And the doctrine of the separation of powers?
That is simply where the government of the state is divided into three separate arms. We know of them as the legislature, the executive, and the judiciary.
Please raise your voice.
I do apologize.
You do want the commissioners to hear what you have to say.
It's where the government of the state is divided into three arms: the legislative, the legislature, the judiciary, and the executive. And its purpose, from what I understand, is to ensure that there isn't a consolidation or a gathering of power in one place. And it's intended to devise measures to ensure that there isn't an abuse of power.
And the independence of the judiciary?
Well, that is vital. Judges hear cases based on the evidence that's brought to them, not on what someone tells them to do.
Thank you. Acting JP, I now give you an opportunity to put questions to the candidate.
Thank you, Chief Justice. Good afternoon, Mr. Mosop.
Good evening, AJP.
Just a few questions for you. I'll make a statement first and ask you whether you agree with the statement.
Yes.
The general thinking nowadays is that the white males are no longer required in the judiciary. However, in my view, the white males are required in the judiciary to address the question of diversity on the bench, provided they embrace the new constitutional dispensation and that they are committed and dedicated to protecting and promoting the constitutional values and human rights, and to serving all South Africans. Am I correct?
I believe you are correct, AJP.
What is your view about diversity on the bench?
AJP, it is essential on at least two levels. Firstly, it's a constitutional imperative. It's in Section 174(2) of the Constitution that this committee must take regard of race and gender when appointing people who are applying, like me, for positions. We're a multicultural, multicolored society. Why should the bench not reflect that? So on a constitutional level, it must occur. But I think that there is another reason why it must occur, and that is that there is evidence that multicultural groups that are called upon to make decisions make better decisions where there is a vast diversity of experiences and people. And where I picked that up is that there's a new book that has been published, I think, barely a week. It's called The Credentialed Court. It's written by an author called Benjamin Barton, who analyzed all the Supreme Court judges that were appointed to the Supreme Court in America. There have been 120 of them. And he found that in the last 20 to 30 years, notwithstanding the fact that people of various colors have been appointed as Supreme Court judges, there was a disturbing similarity, and I use the word disturbing in quotation marks, a disturbing similarity in the people that were being appointed. They all had similar components in their lives. And the first one was that they were all gifted academics. They all did very, very well at university. They came from great academic backgrounds. They all graduated either cum laude, magna cum laude, etc., etc. The second thing is that when they finished at varsity, they all became clerks to then sitting Supreme Court justices. And the third thing that happened was that they all became judges, but not in the state. They became federal judges. The final thing that happened is that a great percentage of them actually became judges in the same court, and that was it's called the DC Circuit, which is the second most prestigious court in America because it has Congress and the Senate, etc., in its jurisdiction. And the author came to the conclusion that that was very dangerous because you got, in the end, what is called groupthink, where people with similar backgrounds and similar experiences start thinking the same way. And you don't need everyone thinking the same way. You need people to think divergently. And his conclusion in the book is that the greater the diversity, the better the decision that comes out of the decision-making body. And he then refined it down even more to the fact that small decision-making bodies who are called upon to answer multiple questions, such as a court, will benefit by having people of various backgrounds, and their decisions will thereafter improve and will be good. I have some skills. I make them available, and I hope that people might be able to learn from my skills, but I see it as a two-way street. I need to benefit from divergent views of colleagues on the bench, because I need to improve myself as a human being and hopefully as a judge if I'm so appointed. So I'm hugely in favor of it on those two levels.
So what skill do you bring with you to the bench?
I answered the Chief Justice that I can bring commercial skills. I have a lot of experience in that regard. But if you look at my career from beginning to end, I have a lot of experience in most areas of the law. I was a criminal magistrate for 5 years. I've been in industry. I've been an attorney. And when, if I recall correctly, when Justice Sutherland applied to be Deputy Judge President of Gauteng, he gave an answer that resonated with me. He said that if he could describe the perfect apprenticeship for a prospective judge, it would be that he has been involved in the law in different capacities, as an attorney, as a prosecutor, as an advocate, and he emphasized the notion of a generalist foundation to your legal knowledge, because he said basically that as a judge, you're going to get a bit of everything. You don't know when it's coming, but it will come. And so if you've got a general grounding in the law, that is a very big advantage. And I think he's correct. So those are the things that I can bring to the bench.
Yes. Do you embrace the new Crystal dispensation?
I do. I do. I think my presence here is the first overt sign that I do that. I've had a very good career. I have a practice that sustains me well. I'm happy to give that up, though, to serve the greater legal community. Another thing that I am prepared to give up, and I'm not sure that everyone appreciates it, but while you are an advocate, there is great risk, because you're working for your own account. If you don't work, you don't earn. There's no employee that will make sure that the till's ticking over while you're doing something else. But the corollary of that is that you have great freedom. If you don't want to go to work, you'd rather go and watch South Africa play Bangladesh in a cricket match, you can do it. If you want to go on holiday, you can do it. I'm happy to give up that freedom to serve. I have embraced the new South Africa, but I think it would also be correct for me to advise the committee that I've been embraced by the new South Africa. It's not just a question of me embracing it. It has embraced me. And I know that time is short and we're on overtime here, but I think I need just 5 minutes to tell a story which will tell you who I am and why I am the way I am. I had been at the bar for about less than 18 months, and I came back to Chambers one morning after being in court, and there was a message for me to contact a very senior silk at the bar. I hope I don't insult Advocate Boise Morani, SC, but the person I was asked to go and see was probably the senior black silk at the bar, Advocate KK Mtiani, SC. And when I got that message, I thought that I must have made a big mistake somewhere along the line. I must have done something really bad, because there was no reason for Mtiani SC to breathe the same oxygen as me. We were at different levels. He was at the top, and I was right at the very, very bottom. In the event, I went to see him. And he sat me down, and he offered me tea or coffee. I don't drink either. And there was a little lull in what was being said. And I said to him, Mtiani, you wanted to see me. And I wasn't being rude by saying Mtiani, because that's how you're taught to speak to people at the bar. I don't approve of it, but that is the way you're taught. It's an old English school system, and I don't like it. And clearly he didn't like it either, because he said to me, please don't call me Mtiani. It is such an impersonal way of speaking to people that you see every day. Please call me Ken. I learned that lesson immediately. And from that minute, that's a thing that I have adopted. I insist that people call me by my shortened first name, Rob. Everyone calls me that. My secretary, the secretary at the High Court who assists me, the usher in the court, the man who mans the boom gate at the High Court, they call me by my name. So that's the first thing that I learned from Ken. The second thing is that he said to me that he had noted me, he'd seen my progress, he'd received very good reports about me, and he had seen me in court, and he liked the way that I spoke to the bench and to my colleagues. At this stage, I began to think that maybe I hadn't done something bad. I thought maybe I'd done something good. And he then said to me, what do you think of these chambers? I knew those chambers. When I was an article clerk, I had briefed the previous occupant of those chambers, who was Vivian Niles Jr., SC, who became the first female judge in KwaZulu-Natal. So I was very familiar with them. They were big, they were square, they were on the 9th floor, and they looked out over the harbour. So I said, well, I told him that story. He said, just go to the window and look out the window and tell me what you think of the view. So I went to the window, I looked out, and it's a view to die for. You look across the Victoria embankment, through the palm trees, into the harbour. I said, it's beautiful. He said, do you like it? So I said, yes. He said, these chambers are yours. So I said, I beg your pardon? He said, these chambers are yours. So I said, are we going to be sharing? He said, no, these are all yours. I said, but where are you going to be? He said to me that he was going to be a judge. And in my naive way, I said, but the JSC hasn't sat yet. And then he said, sit down, and he looked at me, and people who know Ken, he had a really mischievous twinkle in his eye, and he just looked at me and he said, I am going to be a judge. And then I understood. He said, do you want these chambers? And I said, yes. I didn't know how much they were going to cost me, and I didn't know how I was going to pay for them. He said, right, done. And I walked out of there in a dwell. Not because I'd secured these magnificent surroundings, but because Ken, a black advocate at the top of the tree, had taken the time to become interested in me and to show attention to me and to consider me as one of his colleagues. And it was, for me, a profound moment in my legal career. I then said that I made an internal resolution that I would behave the same way that Ken had behaved towards me. And that's what I've tried to do for the last 20 years. I've tried to look after junior advocates as best I can. And I know I've been talking for quite a while, so I'll stop at that point, but there are other aspects that I can mention as to how I've embraced the new South Africa and the new dispensation.
Okay. Do you still want to say that, or you stop?
Well, I can.
But keep it short.
AJP, what are you inviting him to talk on? Were you inviting him to continue?
So he says he has other things he has done in demonstrating that.
I think he said in view of the time he can stop here. So
well, I can mention one thing, if I may, Chief Justice. It came about, I think, as a consequence of COVID. I had finished up an acting stint in Durban on the day that the hard lockdown was enforced, the 27th of March. And so I went home to the lockdown, and my wife is an attorney, and she and I sat at the dining room table every day of the hard lockdown at opposite ends with the printer in the middle. And we worked, and we generated fee notes for our respective practices. And I thought that was true of all advocates. But when I went back to chambers, when we got to level 4, I found that wasn't true, that the juniors in my chambers had suffered greatly. They hadn't had any work. And I saw that 2 months down the line, there was going to be a problem.
I'll allow only 1 minute now on that.
Okay, there was going to be a problem. So what I did was I put a plan in place where I sacrificed portions of my fees to bring juniors into matters, and that has continued since then to now.
Thank you. AJP, I would like to move on.
Just one question, last one.
Yes.
What is your work ethics?
DJP, I'm known at the bar as a hard worker. I go to work. I make sure that I'm in chambers every morning at 6 o'clock. If I'm acting in Durban, I'm in chambers in Durban at 6 o'clock. And if I'm in Pietermaritzburg, I make sure that my goal is to be there by 6:30, but the realistic goal is 6:45 because the traffic can be variable. I stay at work until I've done all the jobs that I've set myself to do. In the time that I've been acting, I've delivered 80 judgments, 40 extempore judgments, and 40 written judgments. And I can tell you that I have calculated, I wanted to be able to tell you scientifically how long it took me to deliver those.
I don't think it's necessary, Mr.
Thank you.
Yeah. AJP, I move on to the MEC. MEC.
Thanks, Chair. Just one question. Advocate, KZN has many areas that are under tribal authorities.
Yes.
And those are areas that are populated by people who are really struggling to access justice through courts.
Yes.
Because of socio-economic conditions that impact on them.
Yeah.
Now, what would you say should be the role of tribal courts to extend access to justice to such people?
I think that's very feasible. The Constitution empowers tribal and customary courts to practice and to do their business, as long as it doesn't conflict with the tenets of the Constitution. You will have seen from my record that I have quite a long association with the Small Claims Court, and I'm wondering if perhaps there isn't a way of introducing both concepts in these rural areas where people can get quality access to justice at no cost. So I think that those courts serve a very good purpose. They are primarily suited for rural areas and for people who are not very sophisticated. And I think they serve a very good purpose. So I'm very much in favor of that happening. And if that could perhaps be introduced together with small claims courts, which I'm quite happy to go and investigate, hopefully that could achieve a very good result for everyone.
Thanks, CJ.
Thank you. I'm going to ask Mr. Mosop to ask you to try and make your answers crisp.
Yes, sir. I do apologize.
Commissioner Nyambi, then it will be Commissioner Nochesi. I don't propose to allow too many questions in view of time. Commissioner Nyambi.
Thank you, CJ. Evening, Advocate Maso.
Good evening.
I'll be failing if I don't appreciate what I'm seeing. The last time you were here in April,
yes,
you were 5 and it was 1 vacancy.
That is correct.
Now you are 7 and we've got 3 vacancies.
Yes.
The secret behind the different person that is appearing to us today, because I've seen a lot of people, once they come for the second time, they even lose a confidence. But I see we are on another level today, so that other candidates that will come here and not get a recommendation, they can learn a thing or two from what I'm seeing.
Thank you very much, Commissioner. It's very kind of you to say so. I think that on the last occasion, it went by too quickly. I was only in for 18 minutes, and I really thought I was winning the game. But I didn't realize I was still in the change room. I am now as I was then, but no one asked me, what is your philosophy about the new South Africa? Have you embraced it? No one asked me those questions. Mr. Ndlovu asked me about his church problems and whether he could rely on the presumption of innocence. Those are all, I was asked abstract questions, but not anything about me. You're seeing me now as I am, and as I have been for the last 26 years in practice.
Oh, let me wish you all the best.
Thank you very much, sir.
Thank you, CJ.
Thank you, Commissioner Nochesi.
CJ, I could have asked you to ask this question. KK, do something that is historic in your life, which changed perception.
Yes.
I'm asking, it's one question, but it's blended into one. Can you speak the Zulu language? Here is a Zulu man. He reaches out to you.
Yes.
He can speak Zulu to show that we appreciate his culture. 2, you mentioned about people that have mentored, and some you give a question.
One question, Commissioner.
Yeah, it's just one. It's based on this. It's based on this. It's based on this. The point, what I'm asking is, out of these persons that you have mentored,
yes,
how many black women that are in that group? Because everybody is to say,
okay,
I have these people, I've done this. How many black women
yes,
and African
yes,
peoples that are involved?
Okay. So to answer the first part of your one question, I cannot speak Zulu. I know words of Zulu, but you may be surprised to learn that I'm enrolled with Professor Nolene Turner, a teacher of Zulu in KwaZulu in Durban, for lessons. I actually commenced lessons in Zulu when I was acting in Pietermaritzburg, and unfortunately the time that the lessons were conducted was at 5 o'clock. I was happy to stay at the Pietermaritzburg High Court and log in with Zoom, but you may have heard earlier in the day that the Wi-Fi doesn't work well in Pietermaritzburg. So I've had to withdraw from that course, but my money is still with her, and I now need to find a time where I can go to improve my Zulu. As the second part of your only question, I've had 7 pupils. I've had 4 black pupils and 3 white pupils. Of the 4 black pupils, 2 were black women. 1 failed. It was the very first pupil that I ever had. I had only been at the bar 2 years when I was given a pupil. The lady had she came from a company background. She had no prior legal experience, and she didn't pass. But the very last pupil that I have had was a black woman who is now in my group. I ensured that she joined my group. And I have, I make no secret of it, and I don't intend to offend my other pupils, but she was the best pupil I ever had. And I expect that in a few years' time, she'll be sitting where I am now. So that's the answer to my question, your question.
Thank you, Commissioner Kleber. And then I don't think there are other hands.
Good afternoon, Advocate.
Good afternoon.
I share the views of Honorable my colleague Nyambi. But what struck me is that you drink neither coffee nor tea. What will you offer me if I visit you in your office?
Coffee or tea or anything else or water, but I don't drink it.
Thank you.
Now I'll go to the commissioners on attending virtually. Is there any commissioner who has a question that they think is very important?
No questions. Thank you, Chief Justice.
Thank you. Commissioner Breitenbach.
No question, Chief Justice.
Thank you, Commissioner Shabangu Mdawe. And no question from Commissioner Barnett. Okay, all right. Thank you.
Chief Justice, Chief Justice, sorry. Short question, sorry.
Okay, one short question.
Thank you. Advocate, if you look at the judgment, the very first judgment in your bundle, so it's on page 107, stop of 108. It's an application, but the question is just this: what type of application is that, and where in the judgment can one read that it is that type of application? Now, the nature of the application.
Sorry, the bundle that I've been given. Oh, sorry, 107. Did you say, sir?
Yes. On the type numbers, it's page 114. It starts the actual paragraph.
Ah, yes, I see that. Yes.
Yeah.
Yes. Well, the notice of motion should have made reference to the fact that what they were asking for was a declaration that the time bar clause was contra bonus mores. It's not actually in the notice of motion, but the body of the application dealt with that evidence, and that's what I was called upon to determine.
Yeah, it's just that I put it just that the reader obviously should be able to understand what this is about, and one reads through this whole application and you just realize it gets dismissed. You're not sure what's being dismissed.
Well, under paragraph 15, it deals with the question of contra bonus mores, and that's what the thrust of the application is about.
Thank you, Chief Justice.
Thank you, Commissioner Barnett. We have come to the end of this interview. I take this opportunity to thank you for availing yourself, and we'll give you 3 minutes if you have 2 or 3 points that you want to emphasize to the commissioners that they should bear in mind as they consider your candidature. But if you are happy that all issues have been adequately addressed, that will be fine as well.
Chief Justice, I've been given a very fair and pleasant hearing. I'm covered,
yes,
to use a phrase that you chaps use.
Yes.
Thank you very much, everyone.
No, thank you very much, and you are now excused.
Thank you very much, sir.
Thank you. So,
Good evening, Chief Justice.
how are you this evening?
Hey, I'm shivering, Chief Justice. But I hope I'll cope.
No, you will cope.
Thank you very much, Chief Justice.
You'll cope. Before I proceed, I need to make a declaration in regard to this candidate. We were at high school together many decades ago. He was, I can't remember whether 1 or 2 classes ahead of me. Was it 1 or 2 classes ahead of me?
2, Chief Justice.
2, yeah.
Yes.
In 1976, and I think he was. We were in this.
I went up to matric, Chief Justice, yes.
Oh, so we would have been together in the same school for 3 years, because when you were in matric, I would have been doing what was called Form 3.
That's right, Chief Justice.
Yeah. And I think he recruited me to an internal football club. And maybe some of you won't believe this, but I was a very good striker.
Yes. I even remember, Chief Justice. I even remember.
I played number 9.
Yeah.
Well, are you confirming what I'm saying?
I am, Chief Justice.
You see, there is a witness who is corroborating.
We need proof, Chief Justice. We need proof.
We do.
We need proof.
He too was a very good soccer player. He was a great dribbler. So I wanted to declare that we know each other, but over the past whatever years, is it about 50 years now if you count from those years? Over the years, I think I've seen him very infrequently.
Yes.
I don't think over the past 40 years I've seen him more than twice or thrice, but occasionally we have been in touch. So I just thought I would disclose that, but also just take this opportunity to make sure that there is a witness who can corroborate that I was a striker. Okay, all right. Thank you very much. Mr. Poswa, I'm going to ask you questions, and after I'm done, I will ask the acting judge president to ask you questions. Thereafter, you will be asked questions by the MEC who is representing the Premier, and thereafter it will be those commissioners who might have questions for you.
I understand, Chief Justice.
Yes. I see that in terms of qualifications, you have a Diploma Juris, a B Juris, an LLB, and an LLM. You obtained the Diploma Juris and B Juris, I think, from the University of Zululand. The LLB, did you get it at University of Natal, KwaZulu-Natal?
No, also from the University of Zululand.
Of
Chief
Zululand
Justice.
as well.
That's right.
Is it only the LLM that you got from the University of KwaZulu-Natal?
That is correct, Chief Justice.
Yes. The Diploma Juris, once you obtained your B Juris, did it still stand on its own, or did it not get subsumed by the B Juris?
I think
if you do a Diploma Juris first and then you do a B Juris, don't you get enough credits so that it's only the B Juris that you hold after that, and the Diploma Juris falls away?
I think it may be like that, Chief Justice. I think it may be like that.
Yes, because the subjects would have been very much the same, except that the ones for the diploma juris might have been at a diploma level, and then the juris ones would be a little advanced.
That is right, Chief Justice, yes.
Okay, and then you got the diploma juris in 1985, and the juris in 1987, the LLB in 1996, is that right? Or is that correct?
I think so, yes, Chief Justice.
Yeah.
Yes.
Okay, all right. You started your working career as a clerk in the Department of Finance in the KwaZulu government, and later on you became a clerk in the Department of Justice under the KwaZulu government, and ultimately you became a prosecutor at Pungashe Magistrates Court, and later on you became a magistrate. Was that at Pungashe as well, initially?
In Ikopo.
Or at Ikopo?
Yes, yes.
You became a magistrate there. And I see that you were doing both civil and criminal matters when you were a magistrate.
That is correct, Chief Justice.
At Ikopo.
Yes.
And later on, 1999, up to now, you became a regional court magistrate, is that right? Or you say it's presiding officer, I assume that's what.
In 1999, Chief Justice, I was transferred from Ikopo to Magistrate Camperdown, still as a district court magistrate. And in 2010, I was then appointed a regional court magistrate.
Oh, okay.
Yes.
Okay, well, here it's written 1 August 1999 to date. Magistrate, Regional Court, Presiding Officer, Criminal and Civil Court. Okay. And then you sat as an assessor in the High Court with Judge Msimang for certain periods in 2008, is that right?
That is correct, Chief Justice.
Yes. And you have also acted as a judge in the High Court in KZN.
That is correct, Chief Justice.
Yes. Are you able to share with the commissioners about, share the length of the period of your acting stints if you put them together? How many weeks or how many months they were, or is that something you have not worked out?
I think I did try to work that out, Chief Justice. I may be wrong, but I'm subject.
Yeah, even if it's not exact, if you give us just an idea. 20 weeks, 30 weeks, 40 weeks?
40 weeks, Chief
About
Justice.
40 weeks?
Yes, Chief Justice.
Oh, okay.
Yes.
Now, let us talk about your civil and criminal, your civil court experience, starting from the district court.
Yes.
What types of cases were you doing as a district court magistrate in terms of civil matters?
Well, Chief Justice, I was dealing with evictions. And I was dealing with matters involving defamation. And yeah, and also those relating to damages. But of course, as you know, Chief Justice, the jurisdiction is limited. That's right.
When you talk about damages, what types of damages? That damages arising out of road accident fund matters, or car collisions and so on?
Car collisions and assault, Chief Justice.
Yeah.
Yes.
Okay.
Yes.
And collections, you got involved in collections or not really?
That's it. I was also involved in collections,
Yeah,
and I was also involved in maintenance matters,
yeah.
and yeah.
Okay, yeah, no liquidations and insolvency matters?
I only met those when I was in the High Court, Chief Justice, not in the
Oh.
District Court.
Okay, all right.
Yes.
Okay. And of course, you would have done a lot of criminal matters.
Certainly, Chief Justice.
Yes.
Certainly.
And the civil matters, did you produce a lot of written judgments?
I did.
At that stage?
I did, Chief
You
Justice.
did?
I did.
Okay. And then you went to the regional court. There, have you been doing civil and criminal matters?
I grabbed the opportunities also there, Chief Justice.
Yes, yes.
And I wanted to balance things.
Yeah,
I did both criminal and civil.
okay.
Yes.
Okay. And at regional court level, what types of civil matters did you get exposed to?
Those will involve, again, damages, as I've said, unlawful arrest, malicious prosecutions, and damages, as I've said, arising out of collisions on the roads, as well as collections. That's right.
Okay. And when you acted for the first time in the High Court, how did you find that experience?
Hey, Chief Justice, it was an eye-opener in the sense that I happened to be in Durban. But before I went there, the late Judge Msimang had warned me that there is a lot of work in the High Court and more so in Durban. And I found that to be the position. But because, Chief Justice, as you have said in your opening remarks, we were taught to work hard. That is our motto. And though it was difficult, the volume of work, you knew in these things, insolvency, liquidations, and motion court, opposed, unopposed, civil matters. You've got to think on your feet, and you must reduce your hours of sleep, because you must ensure that when you go to court with those files, you know what the issues are in a particular matter. You cannot take chances. That is what I would say was my experience, Chief Justice.
Yes.
Yes.
In the district court, had you had your occasion and regional court to do motion matters?
Motion matters, Chief Justice, we do not have there. It's just civil matters.
Yeah, both also in the district court?
That's right, Chief Justice.
Oh.
Yes.
So you were encountering motion matters for the first time in the High Court?
Exactly, Chief Justice.
Yes.
Yes.
Opposed and unopposed?
That's right, Chief Justice.
Yes. And would you say you coped successfully?
Under Judge Msimang, I would say I coped because he did not throw me away.
Yeah.
And
yes.
That man, at any given moment in time, he would have thrown me away without any hesitation if I were not performing. Yes. Yes.
And Did you do civil trials in the High Court?
I did, Chief Justice.
Yes. About how many civil trials would you say you have had a chance to do in the High Court, more or less, during your acting stints? 10, 20?
I put them at 15, Chief Justice.
About 15?
About 15.
Okay.
Yes.
And the weeks when you have done motion court in the High Court, about how many weeks would that have been? Or did you not do them per week? You did them only on certain days?
We were doing them on certain days.
Oh.
Yes.
About how many days would you say you have done motion court if you put all those days together, roughly, even if it's not exact?
Because it used to be Tuesday and Thursday.
Yeah.
In a week.
Yes.
I was there 35, 40 weeks.
Yeah. So it would have been, you said 2 days a week.
That's right.
So 40 weeks would mean 80 days of motion court.
That's it, Chief Justice.
Yeah, okay,
Yes.
okay. And you have produced judgments in motion court, eh?
That's right, Chief Justice.
Yes. Now, any of your judgments that you have produced in the High Court, have any of them been reported?
Unfortunately not, Chief Justice.
Not yet, okay.
Not yet.
Okay, what is your understanding of the rule of law in terms of what it is?
My understanding is that I got interested in this concept, rule of law. And I got to know, when I traced it, that it was advocated by this English human rights lawyer, Dicey. And it's just to the fact that more so that we are a constitutional state now. Matters that involve legal disputes must be brought to institution called courts, where they'll be dealt with, in our case, in terms of the Constitution and the law. That is my understanding, Chief Justice.
And your understanding of the doctrine of separation of powers?
Chief Justice, my understanding, I would say, is simply in the sense that I understand that we've got the executive, the legislature, and the judiciary. And the purpose thereof, I take it and I should think it is that there should be no conflict between these three, more so in the performance of each one in relation to the duties assigned to each.
And the independence of the judiciary?
The independence of the judiciary, my understanding is to the fact that the judiciary, as forming part of the three that I've referred to, is that the courts are independent. And the judges should not be interfered with. There should be no interference, because the judges must not only be impartial, but they must also be seen to be impartial. That is my understanding of the independence of the judiciary.
Yes, no, thank you.
Thank you,
I will
Chief
now
Justice.
give the AJP the opportunity to put a few questions, and Thereafter, I will give the opportunity to the MEC. They will put crisp questions to you, Mr. Poswa,
Yes.
with a view to satisfying themselves how your appointment, if you were to be appointed, would meet the selection criteria that this commission has approved. It would follow in making recommendations of candidates to be appointed as judges. I would urge you to do your best to give them crisp answers as well.
I'll try my best. Chief
Yes,
Justice.
okay,
Thank
all
you.
right. Okay. AJP?
Thank you, CJ. Good afternoon, Mr. Poswa.
Good afternoon, Acting Judge President.
So I just put not much questions. Are you satisfied that you are now ready for permanent appointment?
Yes, Acting Judge President, I am.
So don't you think that you still need more exposure?
No, Acting Judge President, I think I'm ready.
The GCP is of the view that you fail to grasp and apply foundational principles and concept of civil law and procedure, and in support thereof, they refer to the application where you dismissed an application instead of striking it off the roll, and also to the spoliation case where you demanded that the lawfulness of the initial occupation should be established. Do you have anything to say in this regard?
Yes, I do, Acting Judge President. I'll start off with the concern that I'm failing to grasp the basic principles of civil law. That is not true. In fact, what happened in the first matter, it was said to be an urgent application. As I've said, I read the papers because I wanted to satisfy myself that indeed the matter is urgent. I could not find anything urgent. I read the papers again. I could not find anything urgent. So I then said to myself, okay, I'll be going to court the following day, tomorrow. I'll have an open mind open to persuasion. And I got in there, and we started off with the matter. My first question, I directed to the legal practitioner of the applicant. Please, could you address me on agency in as far as this matter is concerned? Legal practitioner addressed me. Of course, in between I was asking questions. Eventually, she concluded. I then gave the opportunity to the legal practitioner for the respondent. Legal practitioner for the respondent addressed me. Then I came to the conclusion that there was nothing urgent in this matter. And it was a clear indication that it was nothing else other than abuse of court processes. I had to intervene. But now, I always, even when my colleagues ask me, I always stress this. Be very careful. If you find that there is lack of urgency, do not dismiss the matter. Just say the matter is struck off roll for lack of agency. I always say that even to my colleagues. I know that. Now, I've since realized that I said the matter is dismissed for lack of agency. And which is wrong, I must concede. Why is wrong? Because it closes the door to the litigant. But if I had said, as I should have said, the matter is struck off roll for lack of agency, the litigant could bring the matter at any given moment in time. But as I've researched, I think Rule 42 is applicable in this matter because that was not the intended order by the court. Then I add in that regard, I must concede. Then coming to the second one, it was, I would say for purposes of simplicity, it was an application for spoliation. What was in issue there was that the applicant was arguing that he had been despoiled. And what was in issue, the subject matter of the application, was an immovable property. Now, when reading the papers, this immovable property had been executed after liquidation of the company. And it was then in the hands of the liquidators. The liquidators, because they had to realize the assets, amongst other things, for the payment of the creditors. They put up this property for sale. The respondent, first respondent, made an offer to purchase the property, and his offer was for the sum of 2.6 million rands. They agreed, and there came a day and the first respondent wanted to go and inspect the farm. He went there, he found that the farm was guarded by the security guards because the liquidators wanted to prevent further vandalization of the house because no one was there.
Chair, I suggested that, I don't know, I don't want to be rude really, but I'm not sure as to whether the acting judge president would not want to intervene or the chair intervene in terms of the fact that we have restricted ourselves to time and also find a way of directing the candidate in relation to the things that he has been asked to comment on, but I don't know.
I think I think the AJP is about to be done. Just keep your answers short, Mr. Postler.
Thank you, Chief Justice.
Yes.
To cut matters short, I found that because the requirement, undisturbed and peaceful possession, in this matter that would be occupation. First applicant and other applicants were never in any undisturbed and peaceful possession. Then I dismissed the application.
AJP, are you done?
No, not yet. I'm about to finish. The other thing is that you tend to make up your mind too early before hearing full arguments in a matter.
In that regard, Acting Judge President, I do not think that would be proper, because the natural rule of justice, you hear both sides.
Well, I wonder at AJP whether they give one or two examples, because it's very difficult to just respond to a general statement like that.
No, it's just a general statement. There's no specific in this one. Maybe I can withdraw it.
Yeah, I think move to another one that is
And go to
substantiated.
The LSSA has expressed concern about your health challenges. Given the rigorous demands on the judiciary, what is your view?
Acting Judge President, my response would be, I've been exposed to the work in the High Court. I know how demanding the work in the High Court can be. As a person, I first have got to be honest and sincere to myself. Ask myself this question. Should I put myself forward for appointment? Do I have the physical, the mental capacity? As I'm here, I have put myself forward because I was honest to myself in that introspection.
Yes. AJP?
Thank you, Chief Justice.
MEC?
CJ, I'm covered by AGP.
Thank you. I don't see any hands. Commissioner Baloyi?
Good evening, Mr. Poswa.
Good evening, Commissioner.
Yes. Mr. Poswa, it's really about the question that I'm going to ask. It's really just to try and find out what support you find when you go into act and what you want to propose. And I ask the question because I've looked at two of your judgments. The one is the Mr. Cool. You remember that? That's a review application to set aside a tender.
Yes, Commissioner.
And the next one, it's the I think MEC Finance, KZN. Then the second respondent is Brilliant. Again, it's about a tender that has been awarded.
Yes.
Now, in both, what is common to both judgments is you are very cryptic in the way that you write. So, and you leave a lot of gaps. In Brilliant, for example, you analyze what the applicant says is the problem with the award to the party that was awarded, right? It says that they didn't meet the requirements, their application didn't contain this and that information. You say that's the analysis of the applicant.
Yes.
And then you conclude, further on, you then conclude that they were favored. The party that was awarded was favored. You don't give your own analysis of the correctness of these allegations. In fact, what is important, I thought, in this judgment is that the second respondent seems to have denied those allegations, but then you then go on to find that the award they were favored, rather. You do that. And then there's the same trend with the case, with the MEC of Finance judgment as well, is you say an award was made of a tender, a contract was signed, and then the next thing, the awardee was demanding performance from the department, right? And then the next thing, they are suing. And it leaves the question, what is the performance that they were demanding? So the reader, internally, the judgment doesn't tell the story. It doesn't tell the reader what, in fact, were the facts on which you decided. It may well be that your conclusion is correct. It may well be. But when you read the document, it doesn't tell you what did you find to have been proven that you accepted and on the basis of which you make your judgment. My question is there support when you act as a judge? Do you find that support is provided to assist you when you write judgments? This is what you should do. in your judgments? And are there any suggestions that you would make that the acting DJP should perhaps look at implementing to provide support to acting judges? Thank you.
Thank you, Commissioner. My response there would be, I know acting judge president is busy, but the spirit that I found in the Durban High Court, in Pietermaritzburg High Court, is such that you can approach any judge for assistance. And I had developed this habit of just asking the judge, please go through this judgment and see if I'm right. And I would say so to the other judge. And when they return what I've written and say, no, it's okay, then I would be content that I'm right. But I understand what you are saying, Commissioner.
Thank you. Thank you, CJ.
Thank you. I don't see any other question. Hence, commissioners attending virtually, is there anybody who has a question that they wish to put to the candidate?
No questions. Thank you, Chief Justice.
No question. Thank you, Commissioner Breitenbach.
No questions, Chief Justice.
Thank you, Commissioner Barnard.
Nothing from me, CJ.
Thank you, Commissioner Shabangu Mdawe. I think we have come to the end of the interview. Thank you very much, Mr. Poswa. We appreciate your making yourself available. I will give you 3 minutes if there are 2 or 3 points that you would like to emphasize, which you would like the commissioners to specially take into account when they consider your candidature. But also, if you feel that important issues have been adequately addressed, that would be fine as well.
Well, Chief Justice, I wish to thank you and all the commissioners for the opportunity, and thank the acting judge president because I'm here of him. Thank you very much.
Thank you very much. You are now excused.
Thank you, Chief Justice.
Thank you. Maybe let's have some deliberation, and then we can take a break when the Secretariat prepare the ballots. Or do you prefer that we take a break now? Okay. Oh, the media, yeah, please.